who should you designate under your durable power of attorney as your decision maker? If you are signing a durable power of attorney, there are several things that you should be thinking about. Primary thing you should be thinking about is who are you granting authority to act on your behalf? That person must be a very capable, trustworthy, reliable person who you know well, hopefully. If you need to appoint a professional person, you might not know them well, but at least you have the security of knowing that they are a professional fiduciary. So I think one of the most important things to think about is who to designate. We'll circle back to that. Another thing to think about is what authority am I granting to this person? Oftentimes people want to grant less authority because they don't want the person that they've designated to have the ability to take actions. For example, change the beneficiary designation on your life insurance or on your will, or do a transfer on death deed on your house, or to do gifting or gifting beyond the annual exclusion amount, which is $17,000 per year right now. The second thing is what authority is being granted, and we'll come back to that again. The third thing that people think about when they're looking at signing a power of attorney and who to designate is, should this power of attorney be effective right now, right when I sign it, or can I just wait and make it not effective until I actually lose capacity and 2 doctors certify that I need help? These are all really good questions and important for you to think about. Let me start with number 3. We call it springing or immediately effective. As an elder law attorney, it's very important, I believe, that your durable power of attorney be effective immediately, not springing, not when a doctor certifies or says that you've lost capacity, 1 or 2 doctors. Why is that? Well, doctors hate to put in writing that their patient is incapacitated. They don't like to do that. It's difficult to do that. And even if they're willing to do so, you might need to get 2 doctors to say that, or somebody to certify that you've lacked capacity. So it's very unwieldy. And as an elder law attorney, we often work with families who are experiencing dementia. And dementia, one day they're doing great. The next day, not so great, and everything in between. So on the days that the person's not doing well, then they, obviously need this help. But other days they're doing okay. And that's the day that they go to the doctor, and the doctor says, I don't know why you're asking me to certify this person doesn't have capacity, because clearly they have capacity. Well, on that day, perhaps they did. So there's this gray zone where a lot of difficulties can happen if you have a power of attorney that is what we call springing, meaning effective only on incapacity. So I definitely recommend that your power of attorney be effective immediately. Sometimes the pushback I get from that is, but I don't want anybody to step in while I'm still capable. I mean, if I designate my daughter right now to be my power of attorney and I'm fully capable, well, she could come in and take all these actions. If that's the case, I say you are appointing the wrong person. Getting back to that really key question is that whomever you designate under your durable power of attorney to act as your agent, your attorney in fact, your POA, it all means the same thing, is that person has to be trustworthy. You have to have no concerns about their capabilities, their motives, their trustworthiness, their integrity. Under the law, they are supposed to act as what's called a fiduciary. That's a very high standard. They're not supposed to act in their interests, only in your best interests. That's the person that you want to designate. And if you don't have that person in your life, then you really should consider appointing a professional fiduciary to serve in that capacity. So if you don't have the right person, then don't designate them. Go to a professional. Then when it comes to what we talked about, what authority, what powers to grant, limiting those or making those expansive. From an estate planning and elder law perspective, I want to see expansive powers. We often find that people, when they come to us and they have a long-term care problem and they need to qualify for Medicaid, there's nothing we can do to help them. There's strategies that would exist if we had the right authority, through gifting, through transfers, through setting up other trusts, through all sorts of mechanisms that we have as an elder law attorney with Medicaid expertise, but if that person has lost capacity and if their durable power of attorney for finances is so limited that it says no gifting, no transfers, we really can't do anything. And that person is left with having to spend down all of their money to Medicaid's limit, rather than us helping them save potentially tens, if not hundreds of thousands of dollars through Medicaid asset preservation strategies. So as an elder law attorney, I want to see a broad grant of authority, which is perfectly fine that you've done that if you've appointed the right person to serve as your power of attorney.